court happens, and that case has been decided, and it's kind of when the losing party has a problem with how the case was decided, either like how the law was applied or if evidence was excluded. Our case specifically is dealing with like they feel that the decision violated the 14th Amendment, and that's usually what YIG judicial cases are about, is constitutionality. So we act in teams of 2 to 3 members. If you have ideally it's a team of 2, because if you have a team of 3 in either of the argument portions, as the petitioner or the respondent, one of the members has to sit out. So if possible, make sure that your delegates are working in teams of 2. We can try and find ways to organize so that unpartnered people will find them someone to work with. 3-partner or group of 3 should only be like the last resort. And your expectation as an attorney is to write a brief, and those are due the same time as bills, both for the rough draft and the final, and to prepare oral arguments that you will be giving at conference. And our case this year is Fisher v. the University of Texas at Austin, which is a real Supreme Court case, and all of our supplementary cases are also real Supreme Court cases. And we have 2 legal questions, and those are kind of what we're arguing about, what the points that are trying to be made are pertaining to, and those legal questions are about affirmative action and how that relates to the 14th Amendment, and the application of something called the strict scrutiny standard, which is what's been set up as our guide for whether or not affirmative action is constitutional or unconstitutional. It has to fall under the strict scrutiny standard, and that's something that is explained in the cases, and if your delegates have any issues with that, I would be the person to contact. It's not really good to get into it here, but if they read the judicial packet, they should understand it. So we have a structure that's modeled after a national judicial competition this year. We have 3 different things that you get to act as: the petitioner, the respondent, and as youth justices. The petitioner is the party that is saying, hey, the decision made by the lower court was incorrect. The respondent is the side that won the decision by the lower court, so they're going to be defending what the lower court had decided. And then as youth justice, the teams will be asking questions and working as justices. The courtroom will always be presided over either by myself or by associate justices, which is an officer position, and delegates will apply for that and be chosen. But we have 2 teams, so it's either 4 people, 5 people, or 6 people, depending on the size of the teams, and they'll also have an opportunity to ask questions and to act as justices. And we have 9 rounds total throughout the 3 days of conference. We don't have any rounds during pre-leg. So a round consists of the petitioners having 20 minutes to speak, and the respondents having 20 minutes to speak, and then a short period of deliberation for the justices, so scoring can happen and it can be decided who won that round. The petitioner speaks first and is allowed to use 5 of their minutes for a rebuttal at the end. They don't have to use all 5. They don't have to use any of it if they choose to. There's a suggested time split later. But then the respondent would speak, and they are not granted a rebuttal. They take their 20 minutes. And then you have to have both attorneys talk for at least 5 minutes, and they can't switch off. Once attorney 1 is done and they sit down, attorney 2 has to finish it off. You can't bring attorney 1 back up unless it's for the rebuttal, and you would only have 1 attorney speak during the rebuttal. And as I said earlier, if you're in a group of 3, each round 1 person must switch off, and obviously it can't be the same person each time. You all need to take turns sitting out the round.
Unless you're a justice, when you're the justices, all 3 of you would get to participate as a justice.
Yeah. So briefs are our writing portion. They are the outline of your argument. They aren't really written in the form of an outline. Here is example briefs for a case. Can you give me one of these to each delegation? So those are briefs. They're not super hard to write. They're example briefs that delegates will be able to see, and they'll also be able to get feedback at pre-leg. But basically what you do is you address legal questions, you kind of show the path that your oral argument is going to follow, and it's so the justices can read, figure out what you're going to say, have good questions prepared for it, and just so everyone understands what's happening and you're thinking about the case. You can get an award for outstanding brief, so So that's fun. That's one of the judicial awards that are available. We're doing that at Kent County Courthouse this year, though, right? That's not going to be at the end.
No, they'll receive their awards.
Oh, it's still part of. I thought. Okay. Yeah. So you can get an award for that. Those you want to put work into them. It can kind of seem hard, but hopefully the example will help. And once again, at the end, my email will be there, so I'm willing to work with any of your delegates that have issues at all. And we recommend that everyone works together on both sides. In judicial before, we've had issues where the work has been divided up and the partners don't really understand each other's arguments. So we really encourage that it's a team effort. Tell your delegates that they should all work together as both the respondent and the petitioner so that no one really doesn't understand what's happening. That can create problems at conference. And then oral arguments, that's like the big thing that we do at conference. Kind of once you get to conference, briefs aren't important anymore. They are, but your main focus is oral arguments. As I said earlier, there's 40 minutes of speaking per round. Each side gets 20 minutes. It's like a conversation. It's not supposed to be mean. There is a form of Parley Pro, and that's in the judicial packet, but it's not as strict. It's basically only what you say at the beginning, and then throughout you just get up there and talk. You're allowed to have index cards, you're allowed to have your brief, you're allowed to have notes, so you can look down at those the whole time. The justices aren't supposed to scare you or to make you feel stupid or anything. They're mainly there to understand your argument and to get what's going on. So you will get asked questions. The first 2 minutes, the justices aren't allowed to ask you questions, so you can kind of get your footing and be able to start without being interrupted. But it's really not scary, and it gives your delegates a lot of opportunity to speak. You're not speaking in front of a lot of people, but you are speaking a lot. With the amount of rounds there are, you definitely get plenty of opportunity to speak. And so we recommend that, like, before oral arguments, you've rehearsed. You don't want to get up there and give your oral argument for the first time at conference. That might be kind of scary. And you can listen to the real oral arguments for the Supreme Court cases that are both the University of Fisher case, like our actual case, and then the supplementary cases that we add. All of those are available on a site that I link to later, and that's really helpful. So you can hear what questions the actual justices asked in that situation. And also, you should plan how you divide out your time. I added a section later. It's not on here. Oh, did you not get that email?
I got the email, but it's alright.
Okay, yeah, so the suggested time split is for the petitioner, for the petitioner, the first attorney speaks 9 minutes, the second attorney speaks 8 minutes, and then 3 minutes are reserved for the rebuttal, and then for the respondent team, just 10-10 for the two attorneys.
But you can split it up 15-5 if you want. It's just one person. Both have to speak for at least 5 minutes. You can split it out however you want, because you might have more information for one argument.
Yeah, but try to make sure it works out that everyone does speak an equal amount. If you do 15-5 for one, maybe do 15-5 for the other, so that no one's talking for like 75% of the time. Judicial review is another segment that we do. We have 3 rounds of that, 1 on each day of conference. We don't do that at pre-leg, just preparation. So judicial review deals with the constitutionality of bills passed by youth and government, the legislative portion, and signed by the governor. The partners are assigned during trainings and elections conference, which is another name for pre-leg. That's when that will happen. And you're going to be assigned with people definitely from not your delegation, hopefully even like from different areas of the state, so that you get to know new people, you get to work with new people. And at Judicial, you're not just isolated and always working with your same partner. We don't want that. And yeah, those are when our rounds are. The Sunday round, if your team makes it into our showcase round, which is like the final best arguments, those teams are allowed to sit out of the judicial review, but everyone else will participate. And then for pre-leg, we want you to have completely read your judicial packet, which is kind of long, but it's super important. The judicial packet contains our rules, the structure, the actual case, and then the supplementary cases. And this is really important because we operate under a closed case structure. Yeah, is that what we call it? So everything that your attorneys are allowed to use in their arguments is contained in that packet. They aren't allowed to go out and bring in other cases unless they're referenced, but that's a whole other thing. Basically, just stick to what's in that packet, and that's why you want to make sure you've read through it, because since everyone has the same material, you guys all kind of have the same starting position, and you want to be familiar with all the information. Even if you don't use that case, you want to make sure that you are ready to rebut the argument of the other side if they use that case. And you need to have your briefs, your rough drafts, your briefs written. You also need to have rough questions for like when you're a justice drafted out, and a plan for your oral argument. This is really important for what we're doing at pre-leg. You get a chance to practice all of this. Your brief gets looked at. You get a chance to do oral arguments. You get to work with an attorney some, and you get a chance to practice being a justice. So you're only hurting yourself, like as a delegate, if you show up and you don't have any of this prepared. It would be a waste of a day. So you want to come and have stuff done. And yeah, like I said, preparation is vital. And then at conference, obviously at this point, you definitely need to have read through all of the materials. You need to have finals ready for everything. And ideally at pre-leg, you and your judicial review partner or partner group, I guess, not partners, but you would have exchanged contact information and started thinking about what you're doing for judicial review. Our only planned time for preparation for that is at pre-leg.
You actually will have 45 minutes at conference in the morning.
Okay, so now you have more time at conference. That's good, but you at least want to be familiar with the bills you're dealing with there, so that you aren't like using the 45 minutes to say, hey, what are we talking about? And you need to be ready to work and have fun. And then NJC is our version of Kona. I'm sure you all know what Kona is, but we get to go to Chicago. It's a case that would be pretty similar to this in structure. It's another closed case. All the information is given to you. Last year was about the Fourth Amendment and dog sniffing and marijuana, cars and houses and stuff. So that was fun. I think we went for 4 days, right? 3, 4. And so we get to send 6 delegates, which means that you have a better chance of going to Kona, just like numbers-wise. So that could be a good recruitment point for Judicial. You get a really good chance of going to NJC. It's a lot of fun. It prepares people for going into leadership in Judicial, hopefully. And it also just gets them more familiar with our structure. Each year that Judicial has progressed, we've moved more toward NJC. So that's a lot of what we're modeled after.
Awesome pizza, too.
Yeah, really good pizza. It was fun. You actually get to go places. In Kona, you're like stuck on the mountain, but at NJC, we get to like go around. Like even during lunch one day when we all had a break after, we didn't have to argue, like we just got to leave and go around and get lunch in the city, and it's a lot of fun. So here's the info that you need. You go to yigde.org and go under forms and documents. That's where the judicial packet is. Sam also is distributing those to delegations, so you should have hard copies, but you need to access them at home. That's where you would go. OEA.org is really helpful. That's where you would have the oral arguments, both the audio of it and also the transcription. So your delegates definitely should take the opportunity to listen to that, get familiar with what's actually going on with those cases when they were argued in front of the actual Supreme Court. I made a video that kind of covers this stuff a little bit less in depth. That's on Delaware YouTube channel. And we also have under this isn't on here, but under helpful resources on DEIG, there are links to things like how to read through Supreme Court cases, because you're actually reading the real opinions and dissents when you're reading the judicial packet. There's stuff about how to give good oral arguments. There's like 10 links on there, I would say, roughly, for judicial.
There's 4 videos.
Yeah, videos.
And some articles.
Yeah, so videos and articles, and I really encourage all delegates to watch those. And then that's my name and email, so write that down and give it to your delegates if they have any issues. I'm really willing to work with everyone, because I get this is confusing, but I want people to love it as much as I do. Are there any questions?
I have a few questions.